Item 37, Rate Appeal 1779 of 2025.
Yeah.
In the meantime,
Your matter.
there has been some development. Another coordinate single judge. Orders of one honorable single judge is being challenged in writ appeal here. Now, another coordinate bench of another honorable single judge has been pleased to pass a final judgment declaring the said order, his judgment, which is assailed here before your lordship, as
For inquiry.
per inquiry. Against that order, it has writ appeal is being
Because there
finally
the
argued.
question was
Finally,
we are the appellant there, my lord, and we are the opposite parties in the writ application. There the question was whether in absence of a quantifiable data, there can be a reserved sentence can be given promotion. Here it is completely reversed, this case. Here it is reversed to the extent that it is a case where even though the reserve candidates were senior, they were not considered promotion as against general category post. So that is a second question of law from Savarwal to your lordship's decision. Then Justice Panigrai's decision, then Justice Sasikant, then there are several judgments of the Supreme Court, my lord. I just found out few, my lord.
Mr. Monty, let him start then. Let him argue, then let him reply.
that matter is fixed to finally be argued on 27.
It's where they
27.
Man, I was only
We call this matter on the fourth.
that matter as I
Post
told
that,
you, that- what has happened?
for that we'll also get ready to assist you.
No, 27. That matter is, let him have the benefit of that judgment.
Yes, all those issues are there also.
27th, where that benefit judgment will not apply, my lord.
That we can say only after reading the judgment.
To have your lordship's consent.
That will not apply because it is not a case of reservation in the.
Mr. Monty, there is some observation by one of the judges saying that the judgment is per inquiry.
Yes.
No,
There is some observation.
Man.
You don't dispute.
Whether you, but
In Hiranmay Naik case.
Hiranmay Naik.
let's forget it. Your lordship's decision.
No, that we will have the benefit of other wisdom.
When Justice Mishra's decision.
So, all these things we consider on 5th of May.
But your
After
lordship.
fifth, after fifth.
After
No,
Other matters are there.
I have strong objection in this
Sixth.
matter because
Sixth.
your lordship see, we waited for years
Sixth,
in the read.
Yes.
And it was made subject to the result of the reflection. Then we got a judgment in our favor. Then your lordship told that case should not be disturbed.
we'll have
on sixth.
On sixth.
Sixth, your lordship. In the meantime, we'll post your lordship with the development.
That's
in
all.
that.
27th minute, that is only for giving written notes for convenience of hearing will not be
I think it's
on that day.
with great respect to our learned senior court said that we'll hear on that day, we'll give you a little notes also. We'll place it. Interim orders to continue.
Interim order.
Wait for it.
And I have been deprived for years together.
No, now you
In
make
spite of my
it.
seniority. Let's hope that it is done in 6.
One connected matter is also there, Lord.
Two matters are
Three
there.
matters.
Three matters are there.
For another
Out of three, two are arising out of the same judgment.
That Lord's matter has also
Exactly.
come to this bench. It has before this bench. It has come here. Yes, yes. That is a connected matter. It is tagged.
Lalit Naik's case.
So the case has not been tagged.
It has not been taxed.
That is,
This is Biswanath Sahu. The second one, my lord.
Lalit Naik.
with
So it is
that
in the
case,
case.
no counter was filed by the appellant. This writ appeal. They didn't file any.
My lord, the second sub item.
For an appeal.
Second of 37.
2395.
2395 of 2024.
There are three matters.
7, 36, 37 to come
No, my lord.
together.
37 sub item number 2.
No, 37 itself is not the item. 37 is also item.
Yes.
37,
And 37 sub-item is also item.
Yes.
And 36.
Yes.
All the three to come.
No, not 37. Why not in 37, three matters are there.
Right.
Two sub-item is there and 37 is the main matter, Sushant Kumar.
There,
41. In three sub-item matters,
This is-
The service is not complete. Service is not complete.
Receipt showing service of required number of copies and AC not.
sub-item.
Uh, With soft copy WP to away. Have you received it?
Yes.
You have received it. Government side not complete.
See, in
No,
respect
government we have received.
Unserved notice for proforma
Respondent number 9.
8, 10 and 11. Returned address is refused. So it is held sufficient.
8, 10 and 11.
Left without instruction, no such person in address. Letter to sender. Proforma name.
8, 9, 10. Millard, these 4 persons denoting the same persons in sub-item number 2 is the petitioner. It is not required because there is two.
who is there at okay? We will request him to accept notice.
Mr. Rao.
One copy.
Mr. Palit is there.
I will serve.
One
Mr.
copy.
Palit is there.
I'll serve.
He has to serve a copy.
Serve good.
Learned counsel, so and so, requested to accept notice for
Judgment to data from the.
response numbers.
Millard, respondent number 9 in the first item.
In the first item.
So,
Then
There are two writ appeals. One judgment.
in fact, Millard, 3 writ appeals are there.
Yeah.
In 3 writ appeals,
service to
it arises.
respondents 8, 10 and 11
Yes.
is held sufficient in view of reported refusal to accept service. Okay.
हमें पुरुषोत्तम
Learned counsel also shall accept notice for who are other persons.
Other persons were not abused.
No, they are served, no? No, there is one person who is not served.
one person left.
R4, R6.
Yes.
Moreover,
R4, R6, who are they?
R4 or 6.
Rohit Kumar Naik and Rohit Kumar. It is it. No. One Rohit Kumar Naik is a so both are
6.
Yes, but that is have to pay for it. We can hold them as service submission. Right. Service of notice on R4 and R6 in writ appeal number 1779 of 2025 is held sufficient. Since neither the postal cover nor the acknowledgement has returned to the sender. And therefore, delivery is presumed. Come on, by resuming delivery. By resuming delivery. Okay. Then, that's how. We'll have this matter on 6th of May.
by one grievance is there.
Yes, sir.
In Lalit Kumar Naik's case, we were not a party in the main, all those repetitions which have been heard. The learned single judge has declared us our judgment to be heard, that is per inquiry, and which would not have been declared for inquiry.
Even if it is declared to be per incuriam, res judicata is not diluted.
No, I am not.
Judgment as such will bind you. Per incuriam refers to the expression of law in a judgment. But binding order
Declared
will
for,
remain intact.
very strange that it has been declared
Circumstances of my case,
for,
it will be confined.
per incurium,
But
for not considering
per
it.
inquiry also you have to see
Challenge.
it, that you have to challenge it, and under what circumstances. What is the learned judge ignorant about?
There is no reasoning for declaring it. Except telling that the earlier judgment has not taken notice of Nagraj. Why should they take notice of Nagraj when it is a question of promotion to the general vacancy?
So circular was
Nagraj did not relate to promotion of a reserved candidate to the general.
never directed promotion.
That is what my contention is. That there is a reservation in respect of the reserve candidate, that is a reservation in promotional post.
Then Nagraj applies.
Then Nagraj will apply the subsequent decision
But
also.
that Nagraj is Nagraj versus State of Karnataka.
Yes, sir. So that is in respect of 16(4)(a).
Correct. Amended the provision of the constitution.
While upholding that validity, they told that but that is also, we cannot say whether
Not
how far superior it is.
judgment. That judgment,
That-
that was declared that circular.
So where the promotion is based on consideration of zone and seniority, then the question of Nagraj, where from it will come? If there is a particular reservation for the reserve candidates, reserve classes, then quantifiable data will apply or not apply, whether there is a rule of specific percentage or not as decided by Savarman and subsequent decision. That will be arguable matter. But in case of post,
Promotion of reserved candidate to general candidate.
that
Just on the question of merit.
Not right.
They will be considered, that's all. And to that extent, that circular took away that right. So it was declared illegal. So, and they never directed for promotion. They said the state should work out the promotion. So therefore, that judgment has no application here. Why that Lalit Kumar Naik case for inquirium, that is also, my lords, is illegal. That could not have been declared. I will say it could not have.
That would be a good.
So the decision which declared another decision as per inquirium needs to be declared to be per inquirium. Till our decision is declared to be per inquirium by another court.
And
That is why our Supreme, our High Court said, whether it is for ignorancia, either way, for ignorancia or for
in a lighter way, the argument can also be the reverse.
That is not what Mr. Monti.
No, all these issues. Since my Nagraj senior was submitting, I never wanted.
No, that Nagraj versus State was a case where promotion of candidates to reserved quota was involved. That arose because of amendment to Article 16(4)(a), 16(4)(a) during the previous regime, where they say right to promotion can be provided even in reserved category, which otherwise was not available.
Reserve category along with seniority also.
Of course.
That is challenged.
That is there the quantification.
And this is not just a.
For that purpose, quantified data is necessary.
Quantifiable data representation.
In fact, there is a quantifiable data in respect of the state of Odisha, but somehow or other it was not placed in the before the other bench.
Let us. We have got the rough idea now. What are the lines of arguments we have just noted. That day we need not repeat it. We have already argued.
Your Lordship is fixing to 6th.
6th of yes.
I only pray that it may come top of.
We also pray the God, let us see whether that
Let it be decided before that.
Either way, let it come on top of the list,
let us see.